Welcome everyone to our legal forum here with the Orange County Clerk of Courts. So tonight's forum is part of our Legal Matters Forum series, which is a series that we've been doing for some time to provide free legal webinars like this to the public and provide good information to you. So this evening's topic is child support and family law. So I'm Dane Weister, the Communications Director here at the Orange County Clerk of Courts. Again, thank you for joining us. Now, we hope the information this evening you find tonight is informative and useful. As a reminder, you will be able to submit questions that you have through a Q&A function on your screen there. So all you have to do is click on that Q&A function, type in your questions, and at the end of our presentations, we will look at those questions and have a question and answer segment at the end of the webinar to answer any of your questions you've submitted. And we ask that you also fill out a survey at the end of our presentations, please. Now, this webinar is being recorded. It's being carried live on Zoom on our Facebook page of the Clerk of Courts, and will be posted to our social media channels afterwards. Now, let me introduce you to your Orange County Clerk of Courts, Tiffany Moore Russell. Tiffany.
Thank you, Dane, and hello, everyone. I want to thank you all for joining us this evening for our legal forum on child support and family law. We know this is a timely and critical topic to discuss in today's changing environment. I want to personally thank our staff for creating this legal forum format to be able to provide this service to the community who need access for legal information and make it more accessible. These forums are one of the best ways to provide our citizens access to justice and access to very important information who all have a right to know. All forums are always free to attend, and holding these legal forums virtually has created new opportunities for us to bring them to you easier because it's to you in your own home. So I want to take the time and acknowledge my staff who have worked hard to bring this webinar to fruition, as well as acknowledge our panelists who are with us today. So first, let me thank, from my office, Family Division Operations Support Coordinator, Jennifer Smith, if you can wave at them, Jennifer. From the Department of Revenue, we have David Gillen and Cherie Wright. And of course, we will have a legal perspective from Attorney Anna Rodriguez-Newburn. And lastly, we will have the Honorable Judge Diana Tennis, who will give a perspective from the bench. So again, thank you all for joining us this evening on our very important topic. And I hope you get a lot of information out of today's session. So again, let's get this forum started, and I give it back to you, Dane.
Great, thank you, Clerk Russell. Let's jump right into our presentations then. So first we have Clerk of Courts Family Operations Support Coordinator, Jennifer Smith, who's going to share with us the role and services our office provides when it comes to child support and family services. Jennifer.
Thank you, Dane. As Dane said, my name is Jennifer Smith, and I'm the Operations Support Coordinator for the Child Support team. I'm here this evening to provide you with some insight regarding how child support cases are processed at the clerk's office. I'll start by telling you about the clerk's role. We are the keeper of the record, meaning that it is our responsibility to create and maintain cases, including all documents that are filed with us. We process child support payments and ensure that they are paid through the custodial parent. We issue delinquency notices and judgments, meaning that if the party misses any payments, we'll issue a delinquency notice. And if they still don't make a payment after that, we'll issue a judgment, and that document is recorded with the comptroller's office. We also suspend driver's license only on private cases once we receive a request from the custodial parent. And we provide customer service in person at our office, by phone, or through online communications. We provide a multitude of services, such as filing petitions that are submitted by the Department of Revenue, filing motions submitted by parties, providing payment histories and payoff requests, conducting case audits when requested, and also as well as providing case information and processing payments. Our stakeholders include all parties involved in child support cases, attorneys, the judiciary, the Department of Revenue, Tanhel Rodriguez and Associates, who are the legal providers who represent the Department of Revenue in court proceedings, the Orange County Sheriff's Office, and the State Disbursement Unit, who disperses the child support payments. Let's review types of child support cases that are filed. Child support cases may originate in one or two ways. It can originate through the Department of Revenue, which parties can apply to the Department of Revenue and request that cases be filed on their behalf at no cost. Attorneys for the Department of Revenue appear at the hearings to represent the best interests of the child. All decisions are made by the Department of Revenue, who has the authority to enforce compliance with their orders. However, they cannot incarcerate anyone. The other way is through judicial cases. Judicial cases are filed by pro se litigants, meaning parties who represent themselves. There is a fee required for these to file these types of cases, and all decisions are made by the judiciary. Parties can be incarcerated for noncompliance with any order, and no attorneys are appointed. However, parties are free to hire legal counsel. There are 6 types of child support cases. The first one will be UIFSA registration cases. UIFSA stands for Uniform Interstate Family Support Act. These cases also originate in state. However, the Department of Revenue transfers partial jurisdiction because the payer has moved to Orange County. Any modifications required must be done by the court where the case originated by the Department of Revenue, and the court can make adjustments as needed. UIFSA enforcement cases. These cases, Florida has jurisdiction, but are transferred to another state because the payee has moved. The Department of Revenue will enforce the case, and only the court has authority to make adjustments. UIFSA IDO. IDO stands for Income Deduction Order. These cases originated in another state and are created solely for the purpose of processing payments. Support balances are not tracked, and no hearings are held nor court rulings entered. Administrative cases. These are filed by the Department of Revenue, who has sole authority to make changes to them. Judicial door cases. These are filed by the Department of Revenue, who has jurisdiction. However, DOR will seek judicial intervention. Court orders are required for adjustments to be made to these types of cases. And then finally, we have judicial private cases. The judicial on these types of cases has jurisdiction over the cases and will enter child support orders in the form of an income deduction order. Payments are usually ordered to be made through the state disbursement unit. Next, let's review how child support cases flow. For judicial cases, a case is filed seeking divorce, child support, time sharing, or any combination of relief. Once the case is filed, a summons is issued so that the respondent can be served. Return of service will then be sent back. An affidavit of service is filed attesting that the party was served, who will then have the opportunity to respond. And then finally, a final hearing is scheduled. After the final hearing is scheduled, a final judgment is entered. Keep in mind that during the time between case filing and final judgment, motions can be filed seeking relief. And then finally, in these cases, once the final judgment is entered, modifications can be made if there are any changes in circumstances such as time sharing, finances, or noncompliance. In administrative cases, parties apply for services with the Department of Revenue, who then files the case with our office. Remember that there's no cost to the customer. After an administrative hearing is held, the Department of Revenue will file an administrative support order with us. Any modifications required must be requested through the Department of Revenue for these types of cases. Here are some tips and recommendations to assist you when contacting our offices. If an attorney is retained on the case, all pleadings must be filed by that attorney. Please be sure to have your court case number with you. Payments for other counties cannot be processed by our office. Payment methods accepted are cash, cashier's check, and money orders only. Please bring government-issued identification. A fee of $5.25 is assessed for each payment made on private cases. Payoff requests are $25. Payment histories are $1 per year, and an additional $2 is required for certification. The interest rate changes quarterly. The current interest rate is 6.58%. Driver's licenses suspended by the Department of Revenue must be addressed with that agency. Questions regarding newly filed Department of Revenue cases should be addressed with that agency. Customers can contact us online through the myorangeclerk.com website. They can call us by phone through the number here, and our hours are between 8 a.m. to 4 p.m. And they can also contact us in person by coming here to the courthouse to room 315. Back to Dane.
All right, thank you, Jennifer. Appreciate that information. That was a good high-level overview for everybody. Now we know that we have questions already coming into our Q&A, and we will go through all the questions and get answers for you. We do like to specify, though, that if you have specific case information, we can't get into specific case information during this webinar. But we have folks here with the Department of Revenue, our office here at the Clerk of Courts, who will work to try to get you answers to your questions. So we're going to move on to the second part of our presentation now. And if you'd like more information on the clerk services, remember, you can always go to our website, which is myorangeclerk.com. So up next now, we have David Gillen and Cherie Wright from the Department of Revenue to now share services regarding child support from the Department of Revenue aspect. And joining them to co-present is attorney Anna Rodriguez Newbern, who will give you some perspective on what to expect from a child support hearing. Thank you for joining us, you three.
Okay, well, thank you, Dane, and thank you to Clerk Russell for providing us this great opportunity to interact with the citizens of Orange County and Central Florida and wherever else you may be logged on from. Cherie, are you going to get the okay, there we go. I do want to just provide a little bit of background. First, talking about our vision and mission of the Florida Department of Revenue Child Support Program. And then I'm going to be getting into the services that we provide as far as paternity establishment, support order establishment, and then we're going to talk about what happens after a child support order is entered. Cherie's going to be talking about the back end of the process, and Annie is going to be providing us insight throughout the presentation as it relates to the legal aspects of processing a child support case. I will say that, you know, Jennifer talked about a number of things that will be covered in our presentation. And the as the clerk has a website, we have a website as well. It's floridarevenue.com/child support. And there's a clearinghouse of information out there as far as how to contact us, the services that we provide through the Department of Revenue Child Support Program, including, you know, how to apply and submitting an online application. So we'll go ahead and get started. Just a little bit about the vision of the child support program. We're working with families and partners to help children receive the child support they need and deserve. And we're committed to serving our customers, all of you, with respect, concern, and professionalism. We want to make it easier for parents and to provide support for their children. And we're committed to working with parents, partners in the community to continually improve the child support program. And this is one of those opportunities where we are having a chance to work with the clerk's office, the judiciary, and others in making sure that our customers, our shared customers, have the best possible information to make good decisions on their cases. So getting back to a little bit of the background about our program, families receive child support services through the child support program. They may receive them through private attorneys or by filing their own pro se actions, which is an action that you file yourself in court. We work with many different partners, all playing a part in successfully providing child support services to our families. We are partially funded by the federal government, so the federal government is heavily involved with our program. The Florida courts obviously are involved, local law enforcement, financial institution, employers from all over the state and the country, and other state agencies. And I will just say again, the Orange County Clerk of the Court is one of our key partners, and we have an excellent working relationship with the clerk's office, and we're very, very appreciative of that. So families can request services by completing an application. I just mentioned that. That online application can be found at floridarevenue.com/child support. And so you can complete it online, submit it online. And then if you are receiving some sort of public assistance, like cash assistance or food assistance, you're automatically referred to the child support program for cooperation by the Department of Children and Families, and there are no costs associated with any of the services that we provide. This is kind of a staggering stat sheet right here. We have over 856,000 cases in the state of Florida that involve 879,000 minor children. I will say that the caseloads have dropped over the last couple of years, but the number of children is noteworthy because what it comes down to is about 1 in every 4 children in the state of Florida is under some sort of child support obligation. So that information is important to know, and it kind of provides perspective to what our program and how broad the customer base is for our program. And right now, about 82.3% of families that have a child support case with us have a child support order. And then obviously the other 17 or 18%, we're in the process of trying to establish those cases. I will also add that the Orange County Child Support Office, which actually serves the Osceola County and Seminole County as well, but the Orange County cases specifically represent the largest single county outside of Miami-Dade in the state of Florida. So there is a lot of impact on our local citizens as it relates to child support, and it's great that we have once again this opportunity to provide information so that either if you have a case that you can use it and navigate the system, or if you know somebody that has a case that you can then help them to understand what they might be able to do to get accurate information, because that's the key is accurate information for us to be able to process cases and communicate and make sure that there's good outcomes for everybody involved, especially the children. So we work with families and partners to locate parents, employers, and assets. We establish paternity. We establish and modify child support orders. We receive and distribute child support payments, and we monitor and take action to help parents comply with child support orders. And going back to our mission is we want to try to have relationships and work with all of our customers in a way to ensure that we have voluntary follow-up actions that happen on cases, and that some of the things we're going to talk about regarding the judicial options that we have, we want to make sure that we use those, especially on the compliance side, only when absolutely necessary. So as far as requesting child support services, the child support program receives requests for services 3 different ways, depending on whether a parent receives public assistance and if the parents live in the same state or country. The provided services depend on whether paternity is established and if there is a child support order already in place. Not all parents receive child support services from the child support program. Jennifer mentioned the idea about private cases and then the Department of Revenue cases, and there is a distinction between the two, which we'll talk a little bit about. When the program is not involved, these cases are referred as I said, referred to as private cases, and parents can be represented by their own attorney, or they could represent themselves in a private case potentially. We have situations where a customer sometimes will start out with a private attorney or their own representation, and they decide to use our services, and sometimes they're back and forth. It's completely up to the customer on how they want to use our services. So I talked a little bit about how referrals come to us, how we get our cases, and I'll just talk about that again briefly here. The Department of Children and Family does automatically refer parents who receive cash and or food assistance to the program, to our program for child support services. Parents receiving only Medicaid, they have to apply for services, and you can do that online. And then parents must cooperate with the program as a condition for receiving their assistance. Parents can submit an application. Any parent can request services by completing an application. Applications are completed online, and collect critical information of the parents and children that allows us to do that initial intake and assessment to ensure that we can set the case up for the quickest possible follow-up, depending on what actions are needed to either establish paternity and support, or to ensure that the court order that's in place is complied with and payments are being made. And then we have intergovernmental referrals, where child support agencies in other states and countries request services for parents and children who do not live in Florida. We kind of refer to these as interstate cases. And there are situations where we have the parent with the child who lives in Florida and the parent that is supposed to pay support lives in another state or country, and then vice versa. So we have obviously more control over the cases where the case is open in Florida, but every state has a child support program, and they have an obligation to work those cases and ensure that they have positive outcomes for their families as well. And it does, sometimes create situations where it might take a little bit more time, but we are very, very successful in getting positive outcomes on those cases as well. So parents who already have a support order from a divorce or other action can receive services from our program. In those cases, the private child support case becomes a Title 4D case. The case is coded differently at the clerk of the court. It then becomes a Department of Revenue case. And then the laws that govern those cases as it relates to state and federal then apply, and we can utilize those in establishing and ensuring payments are made in compliance through the state disbursement unit. The parent's existing child support obligation is entered on the child support program's computer system to enforce the order and then process those payments. And parents can request support order modification if the circumstances have changed. If a parent does not have a child support order, paternity must be established before support can be ordered. The program uses genetic testing to determine the biological father. Those test collections are actually, it's a pretty seamless process. We do those collections in our office, and we have a good system in place to be able to manage that. So that is something that helps to quicken the process as well, as far as the flexibility we have in doing the genetic testing. The program then establishes support orders through both administrative and judicial processes. Jennifer talked a little bit about this in her presentation, and the program decides which process to be used based on the case and the legal requirements. Before paternity or support can be established, the parent who may be ordered to pay support must be served with the legal notice and given the opportunity to respond. This is a very critical part of the process, and it goes to the whole idea of us having a collaborative approach to working with our customers as far as the establishment and then the compliance with child support orders, because we want to make sure that we understand and know where you are so that we can either notice you of ongoing actions on your cases that you need to take next step action on, or we want to make sure that if you're receiving child support payments, that the child support and other actions are going, to the appropriate addresses. So we do make sure that that our addresses are up to date. It's based on, what the customers provide us, but we want to make sure that we are getting that most accurate information. We have a number of easy ways for you to get in contact with us to keep us abreast of your addresses. And you also want to pay close attention to what direction you're given in your court orders as far as who you are to notify the clerk's office and the Department of Revenue as it relates to making address updates, because the clerk of the court is the official record keeper.
David, I actually just wanted to chime in with something, since we were talking about the establishment of orders, and for any customers or parents that don't already have an order, it is very important that you answer and respond to all mail from the department. It is very common that some of our customers, our newer customers, they feel like if they receive the notice and if they just don't acknowledge it or respond to it, then, maybe this won't even happen. Please respond to all correspondence that we would ever send to you. If it's for establishment of your order, it could be about the enforcement of your order, but responding to the mail or any inquiries from us is very critical. And I actually just wanted to invite our legal service provider, our business partner, and see if she had any additional information to share about that, because we know we serve our parents, they get a notice, but the importance of that and the things that could result from lack of follow-up from the parent, it's something that could be avoided. So we, again, stress, please answer the mail. Annie, I didn't know if there's anything you wanted to share.
Absolutely. Thank you, Sheree. That is the biggest issue that we see in all of our cases. Tangle Rodriguez and Associates is the exclusive legal service provider for the Department of Revenue in Orange County. So if you have an Orange County DOR case, you're going to have Tangle Rodriguez or one of our attorneys involved in that case. And what we see more often than not is people not keeping their addresses updated. If you move around a lot, if you know that you're going to be moving from apartment to apartment because housing is tough right now, go ahead and sign up with the clerk, register an email address. We're making a shift towards email addresses and using those, and that might be a better option for you. If you don't trust your email spam or your technology isn't quite reliable, make sure that you update your address, your physical address. It doesn't have to be where you live. It can be a PO box, but make sure that you update both the Department of Revenue and the Clerk of the Court, because what we see very often is one gets updated, the other does not. And before you know it, we're down the path of that case where paternity has been established by default, meaning you're automatically the father of a child that you wanted a DNA test for, but because you didn't update your address, you didn't get your shot. And we want everyone to have the opportunity to get a DNA test who requests one. And it's probably a bad dated Kanye West joke, but if after 18 years, you can't go back, it's done and done. So you want to make sure that you keep your information updated with both the Department of Revenue and the Clerk of the Court to make sure that you get that information from top to bottom, because at the very end of the day, you could go to jail if you don't keep your address updated on a contempt proceeding later on in the enforcement.
Okay, thank you both for sharing that additional information. We're going to probably talk about that whole concept of keeping your information up to date, talk about that a little bit more as we go forward. I already talked about interstate cases, so we'll go ahead and go on to the next slide. And I talked a little bit as far as the private cases and the Department of Revenue cases. If a parent stops receiving cash assistance, one of those public assistance methods that requires cooperation, then they no longer have to participate with the child support program. And then when that happens, we simply recode the case as non-DOR, and that becomes a private case. And we have cases that go back and forth all the time, and that's not a problem. But there is a process for that to occur. So we've talked a little bit about administrative child support establishment, judicial child support establishment, paternity establishment. We're going to go into that now in a little bit more detail, including order modifications. As it relates to the establishment process, this is the quickest, most effective way for us to establish a child support order. It's a very collaborative method for establishing an orders where both parents are heavily involved. They know exactly what's going on at all times, and they have options as far as whether they end up consenting to the proposed orders or whether they requested a case go before a judge and have an order entered that way. But just quickly to go through the process, the child support program does establish paternity and child support obligations administratively. Orders established through this process have the same force and effect as a court order. There is a difference as far as the modifications of the admin cases. They would have to be modified administratively unless they are recognized judicially, and that's a process that can occur as well. An administrative action starts by serving a notice on the parent who owes or may owe child support. The key on that is may owe child support. I want to just stress that because when we are trying to identify who the father is and we don't have paternity established, we are basing our follow-up actions on the information provided to us by the parent with the child, and so if paternity is an issue, we are going to be contacting you to potentially do genetic testing, and once that service has been completed the first time, then any follow-up actions that are needed would we would assume that you would be receiving that information. So we want to make sure that there's an understanding about that if you are receiving information to follow up on as it relates to genetic testing, that's really important that you do that so that you can be part of that process. You want to make sure that you know, if you are named as a father, whether you are or not that father. And that does have a lot of ramifications. If you don't follow up and you then think down the road, there may be an issue. We also ask both parents for financial and other information needed to determine the child support amount. Based on the information provided by the parents and the Florida child support guidelines, we calculate the amount of child support to be ordered and mail both parents a proposed order. Parents can agree to the proposed order, provide additional information, or they can meet with us and request a hearing like I just talked about. A final support order that includes an income deduction order is issued and filed with the clerk of the court. The order is mailed to the parents with instructions on how to make the payments. The next way of establishing a support order is judicially. And I think this is a good time I'll kind of hand this off to Annie, and she can kind of take us through the process of managing a case that goes through the judicial process when we are trying to establish a child support order. So Annie, I'll go ahead and hand it off to you.
Sure. And we see these all the time. We receive information from the Department of Revenue. The Department of Revenue is our client. If you need information regarding your case, you want to make sure you pass that through the Department of Revenue. They have amazing caseworkers that will work with you. They package that up, they send it to our office. Then what we'll do is we'll file a petition to establish support or paternity and support, depending on what's needed. Then we will move forward on the next step. So if that's paternity, we will agree to a DNA test. Once DNA testing results come back, positive or negative, we'll get some sort of order to that effect. And then we'll set it for trial. Then what happens at trial is we hope and pray and know that you will be ordered to bring all of your documentation with you, because we're going to be asking you questions about your income, questions about your health insurance, details about your health insurance, so that you can get credit for that in the child support calculation. We're going to also ask you about your other child support orders, if you have those, about the children in those cases, so you get the right credits where you should get those deductions. We're going to ask you about time sharing. We're not going to get into time sharing, but we're going to ask you if there's an agreement and how many overnights you have, if you have an agreement, because that also goes into a child support guideline calculation. We're also going to ask you about daycare or aftercare, should you have that for your child. So you're going to want to make sure that you have the specific information. Don't do the math. We're not asking you to do the math on it, because we have a child support guideline calculation that does it for us. So you don't have to do any math, just bring your documentation so you can refer to that. Better yet, if you can complete a financial affidavit, an updated one, and file it, then you're ready to go to court. Then you'll sit there along with an attorney just like me, possibly me, and we'll take that testimony, put that information into the guidelines, and then the hearing officer or judge, depending on where your case lands, is going to figure out what the amount of support due would be. And that's just based on the statute. So that's us putting your information into that calculation, and it'll spit out a number for us. It's going to probably be a monthly amount of support, and the judge or hearing officer or magistrate will pick a reasonable amount of time from that date so that you can start paying your child support. Those are the things, the tips, tricks that I would recommend so that you would know in advance what to expect when you get there. It can be really intimidating, but I promise it takes us about half an hour or less if you're prepared with all that documentation. It's supposed to be as easy as possible, but we understand that it can be really stressful and intimidating. So hopefully this information will help. I'll toss it back to you, David.
Thank you, Annie. That was very helpful, and I appreciate that information. We're going to go ahead and move on to paternity establishment. And we've talked a little bit about this already, but children with unmarried parents need to have paternity established before support can be ordered. Establishing paternity identifies the child's legal father and has other ramifications as well regarding health history and other things that a child would benefit from knowing both the information about both of their parents. Florida allows parents to establish paternity voluntarily at the hospital when the child is born or anytime after leaving the hospital by signing a voluntary acknowledgement of paternity. If paternity is not acknowledged, it is established administratively or by going to court. We do use genetic testing, as I mentioned earlier, to determine who the biological father is. The final step in establishing paternity is updating the child's birth certificate with the father's name at the Bureau of Vital Statistics. Okay, the last part of the last thing that I want to hit on my part of the presentation is order modification. This is really an important piece of what piece of one of the services that we do provide. We understand that the financial circumstances change for both parents and the ability to pay changes for different reasons. We know we've seen a lot of the obvious ones over the last few years with the pandemic, and now we have issues with the economy and things are always happening that can affect the ability to earn income. And it could also, there's positive things happening too, and people increase the amount of money that they're making, and with that would come an increase in the amount of support that should be paid. So we have a very structured and easy to navigate process to do order modifications. A child support order may need to be changed, as I said, to reflect the current circumstances of the parents and the child. Either parent can ask us to review their support order, or they can try to modify the order themselves if circumstances have changed. The child support program collects information on the change of circumstances and financial information from the parents to determine if the program should attempt to modify the order, similar to what we would do at the beginning of a case where we're trying to verify some of that same information. But we do have to have a case meet a certain criteria for it to warrant modifying it, as far as the amount of increase that must occur either upward or downward for it to be referred for modification. And then orders are also modified administratively through the admin process, and then they're also modified through the judicial process by going to court. So that kind of is an overview of the support order establishment of paternity part of the process. We went over it quickly. I'm sure there's a lot of questions. It's very complicated at times, depending on what the unique circumstances are of your case, and we'll get into questions at a later time in the presentation. But now I'm going to hand it off to Cherie, and she's going to talk a little bit about the things that happen after a case that we do to ensure compliance with the support order amount.
Yes, good evening, everyone. Basically, once a child support order has been established, we work with families and partners to help children get the support they need and deserve. And basically, that means we try to achieve compliance with the court order voluntarily and as quickly as possible. Some of the tools that we can utilize to achieve these goals would be a payment agreement. The payment agreement is basically, it used to be called a written agreement, but it's an agreement that the customer owing support and the department enter into, and we increase the payment amount towards the past due amount. This method of resolution can be used for almost any enforcement action we have, suspension actions, almost any enforcement actions we have, they can be remedied by signing a payment agreement. But keep in mind, payment agreements are always going to ask for more money. So if you are not able to pay your current support as it is, and you don't have the ability to pay more on top of that, we would not want to set anyone up for that type of situation. So that would be between you and the customer service representative that you get in contact with to try and seek information about that. Our most common and most effective form of collecting funds is through wage withholding. And this is basically income deduction notice. And this is when they send a payroll deduction to your employer to have your child support deduction taken out of your paycheck. More than half of all child support collections come from wage withholding. Suspension actions. So the department is able to suspend licenses or deny renewal of a U.S. passport, and the parent would always receive written notice. The parent does not pay, doesn't reach an agreement to pay, or does not contest the actions. One of a plethora of licenses could be suspended. Of course, the driver's license suspension is by far our most common, and it tends to get most people's attention. In the same breath, it is also something that we do realize that if you need and are looking for a job, you may have just gotten out of jail or come upon some tough times and you need to get a license so that you can further your job searching. The department is open-minded with that. If somebody is fresh out of jail and obviously they need their license just to even look for a job, we do have that openness. Nobody is benefiting when the parent owing support isn't paying. So we are always going to want to try and help and advocate for the parent owing support to get them as much support and assistance that we can. But if unfortunately we can't, we can also suspend fishing license, hunting license, professional licenses, cosmetology. So there are a number of anything through Department of Professional and Business Licensing, anything through them we could essentially suspend. Here we have court actions. Our business partner Annie here will elaborate. I typically only touch on contempt because that is our most common enforced court action, and it is the one that is often the most misconstrued. Some people think that, I missed 2 payments and I'm going to jail, and that is just not true. There are so many steps and so many actions that we have to get through before we can even consider contempt of court. And ultimately, we don't even make that decision. That judge or that hearing officer that you go before is the person that will determine if you are actually in contempt of your court order. We just kind of inform you about the delinquency along the way. But there are many other things that happen in court, and I will let Annie speak about that.
Well, and going back to your suspension activities, that is actually something that we can see in court. And many people, I saw at least 3 today, didn't understand that if you have an issue with your driver's license and you haven't, for whatever reason, been able to come to an agreement with the Department of Revenue, you can file a motion and have it heard. And when you get there, the hearing officer, magistrate, or judge is going to look at you and say, what do you want the court to do and why? And if you present your case and you come up with some sort of reason or perhaps a lump sum payment, that's good faith that you're going to start making payments in your case. I've seen cases go in the way of the person asking for their license back. So I want to make mention of that and make sure that you know that you're only going to get that motion heard if you schedule it, if you make an appointment for a hearing and you have that heard and you make sure your address is updated, because you don't want that notice to go somewhere else and you don't read it and you miss it and then your motion is denied and you're stuck without a license. So we see that very common motion in court proceedings. We also see motions to enforce, which are different than motions on contempt. Your motion to enforce is trying to put the payor in a place where they're back to work. So we're asking for a job search. We're asking the court to order the payor to complete that search or to provide proof of disability. We're maybe making an order or asking for an order about a driver's license or a professional license. If you need that, that's the time where we talk about that and what steps we can take to get you back to work. That's very different than a contempt proceeding. If you get a motion on contempt, then it's go time. You've missed a lot of child support at that point, and we're there to talk about why. And perhaps you need a little more inspiration, and the court can consider putting you in jail on a reasonable purge, meaning that's an amount that you can pay to get out of jail. So it's not punishment, it's to try to inspire you to pay or to make you pay a certain amount that the court has found and set as that purge. That's what that means. It's not a bond, it's not bail, it's a purge. And so when you get that motion on contempt and you get that notice, if you were the payor, you're going to see language that says that you could go to jail if you don't show up or if you go to that hearing and you're found to be in contempt. If you miss your hearing on a contempt motion, then what you're going to see next is a writ of attachment. A writ of attachment is like a warrant for your arrest. It's for your failure to appear. We don't ask for a writ of attachment for your failure to pay. We ask for it because you failed to show up. So if you show up, that's half the battle there on a contempt motion. And then we get to talk about how we're going to get you to pay again. Here's the thing. If you keep your addresses up to date and you keep the department advised, if you tell them what's going on, if you went to jail, if you're disabled, if you have proof of disability, you keep them updated. A lot of these enforcement actions are going to take care of themselves and we won't see each other in court. So I just want to make sure to reiterate again, keep your addresses updated, answer your mail, and talk to the department, make sure they're updated on what's going on. But as far as the court actions and enforcement, it's typically in front of the hearing officer on the 5th floor in room 540. You'll walk in and see a deputy, and then you'll get it right into a hearing with the child support hearing officers. If you have some sort of injunction between you and maybe another party, we might be before a judge. And if something else is going on, the judge may decide that we go to a magistrate. But more often than not, it's on the 5th floor, room 540 for child support enforcement. Hopefully I was able to cover that for you, Sheree.
Thank you so much, Annie. I so appreciate that. David, did you have anything you wanted to share about? You're muted.
Yes, because we were talking a little bit about potential situations where a parent who's ordered to pay support is not able to for whatever reason. I want to also encourage you, there's information available on our website that I just talked about that provides job information about job resources. And there are actually some local organizations that have been funded for a grant that is in support of the new legislation that came out of the last session regarding trying to work with fathers or parents who owe support to help them find employment so that they can take care of their responsibilities. So either parent can take care or utilize these resources for parents. But if you go out to that website, you click on the resources for parents link, it then allows you to go to any county in the state of Florida and look at all the different community organizations that are available to them, and specifically the ones that are part of this grant. They have a green badge next to them, and they provide support for job placement, job training programs, veteran services, disability services, and a myriad of other things that might benefit you if you are in need of assistance in gaining either a job or the training that you need to do a job. And once again, that's found at the floridarevenue.com / child support website. So just that's all I wanted to share, Sheree.
All right. Just to conclude some of our enforcement actions, we also have liens to collect past due support. The child support program can place a lien on vehicles, boats, personal watercrafts, mobile homes, and real estate. This tends to be passive. We don't really, the customers, our parents don't really realize this until they go to sell one of these items, and then they realize that this lien has to be satisfied. And our other collection methods are, which has been around for quite some time and is very popular. The child support program can absolutely intercept insurance settlements, IRS tax refunds, unclaimed property, lottery winnings, reemployment assistance, and workers' compensation benefits. Child support can place a freeze on a bank account. Now, the intent is to freeze it. Most people, obviously, you're not going to receive notice. We don't send any notice of when this initiates, but once it has been initiated and the freeze is in place, the affected parent will absolutely receive notice, and they will have the same options. That it's going to be the same 3 options listed that are on all of our notices: to pay the delinquency in full, to contest it, or to sign a written agreement. And that is where, if you do, as Annie mentioned, if you want to contest anything, please make sure it is timely. If not, that leaves the other 2 remedies that you would go through with us: to pay your delinquency in full, or to sign a written agreement. And just as an FYI, because it is bank accounts, and we do realize that our parents owing support, sometimes they have now remarried, they have new spouses. We do have a mechanism in place to not penalize a shared bank account that may be utilized by one of our parents owing support and their new partner. So I just always like to put that out there, just in case that is ever a concern. And credit reporting. Child support is a debt. It's a delinquency, just like a credit card, car loan. So it is reported to creditors. And again, this usually pops up when people are trying to get a house or to get a car, or they're trying to buy some large item and their credit is run. Yes, child support delinquency will show up. There is also medical support. The program can take action to enroll children in health insurance or to collect a child's medical expenses that are not covered by insurance. Certain percentages are established in how to pay uncovered medical support or procedures not covered by medical insurance. So we do collect on that. And then one of the last things that we will collect on is cost. Basically, at the program can collect costs that are owed from a legal action and that are past due by 30 days. You may incur a cost just from the beginning of your case, could be anytime you go to court for contempt or anything else, but cost is something that is paid all the way at the end of a case. If money comes in, that money is going to those children. We would never take ongoing support money with a case that has a delinquency and apply that to cost. Cost or something once a person is completely paid, child is emancipated, case is paid in full, that is when we will pursue cost. We collected 1.59 billion in child support in the federal fiscal year 2021 to 22, 97.8% went to families, and $938 million were collected through income withholding from the parent's paycheck. And if you ever do need to get in contact with the department, there are many, many ways to reach us. And as from that website that David did mention, these methods are listed along with others. We have our e-services, we have email, we have phone, we have web chat now, and of course, we will accept information via fax. And for every dollar spent, the child program collects $5.91. I think that pretty much concludes our presentation.
I'm sorry if I could I just want to add something in closing. The department is very, very committed to serving all of you at the highest possible level. I talked about our mission, that we want to serve all of you with respect, concern, and professionalism. We want to make it easier for our customers to be able to provide their child support and to comply. And we're very committed to working with parents, partners in the community to support those efforts. And we provided a lot of information. We provided contact information. I am the regional manager for child support operations in East Central Florida. We will provide you my email address after we get through all of this. Please, if you want to reach out to me directly, even if you haven't tried any of these other ways, I welcome contact. Ultimately, I want to make sure that everybody that needs assistance gets the assistance they need. And we are very, very committed to doing that. So once again, thanks again for the opportunity, Clerk Russell. And that concludes our part of the presentation.
Great, thank you very much. We appreciate that, great information, and we do have a lot of questions rolling in here. So just want to reiterate for this forum here that we are going to try to get to all the questions and get them answered for you, but case-specific information, we will not be able to answer specific case information, but we'll do our best here, and then David and Cherie and all of us with the clerk's office will try to get your questions answered. So going to go to our last presentation before we get to the questions. And joining us next is going to be the Honorable Judge Diana Tennis, who's going to share with us her perspective from the bench.
Hi, everybody. First of all, I'm so impressed that you all have shown up. This is such a smart thing to do. You have so little opportunity when dealing with these cases, most of you probably pro se, meaning without lawyers, to really get information like this. You're never going to have an opportunity to have a circuit court judge giving you information and answering your questions like you do in this forum. Thank you so much, Clerk Russell. This is just a fabulous assistance and service to our community. So I am one of 10 circuit court family judges in the 9th Circuit, which is Orange and Osceola County. I'm also the admin judge. Now, what this means is when you have a complaint about a judge's ruling, I do not want to hear from you. If you file a motion and you do not get a hearing in a reasonable amount of time, say 30 to 60 days, then I welcome you to find my email. It's on the website, the ninthcircuit.org. I've got my own webpage. You can contact information there, and let me know that you're not getting a response from one of our circuit judges. We are tasked with treating pro se litigants professionally and expeditiously, meaning we are supposed to be getting to your stuff soon so that you can get your cases figured out and get to conclusion and get on with your families. So let me know if you have problems in that regard. I am also super impressed that there are so many of you who have had questions that you've put in the question box. So as I go through my presentation, a few of those questions pertain to judges in the courtroom, and I'm going to try to give you some information. I can't give you legal advice, but I'm going to give you some information that might be helpful to you. So rules apply to you like they apply to lawyers. Now, I will say that judges do try very hard to make it as fair for you as possible. And I can tell you, I can promise you, I have many pro se litigants that beat lawyers in my courtroom all the time. But one of the best ways you can go about getting the outcomes you want is paying attention to the rules because they apply to you. And we're going to talk about some of those here today. This rule is really important. This is the rule that says both sides have to provide mandatory financial disclosure. We're going to talk about more than just child support today, but child support is a huge part of every family case that includes children. You are required to file an accurate financial affidavit, and you're required to provide mandatory disclosure. The short of that is, as it applies to child support, is 12 months of bank statements, credit card statements, pay stubs, the last year's tax returns. If you provide those to the other litigant or the other lawyer, you're probably going to get most of the way there in what you need to provide. But that is a problem that a lot of pro se people have, meaning without lawyers. If a lawyer is on the other side and they file a motion to compel, or even worse, a motion for contempt, alleging that you have not done what you're supposed to do, you need to drop everything and Google and figure out what they're talking about, because we are required to treat you equally. So if you come to a hearing in front of me or any of the other 9 judges and you have not done what you're supposed to do, you will be paying the other lawyers' fees because we have to treat you equally. Filing motions. I'm begging you, my other 9 comrades are begging you, make them readable. If you don't care enough to use good penmanship when you file a motion in my case, why should I care more than you do? Take your time. Take your time. Make it readable. Make it understandable. What are you complaining about having happened? What do you think should have happened that didn't? And what do you want me to do about it? Take your time. Take as many pages as necessary. If you have access to a computer and can type it, fantastic. If you don't, use your very best penmanship and take your time. Do not run to the clerk's office in a heat of passion and scrawl out, I'm angry about something, and it's got to be understandable. Include details, include dates. If you're complaining because something hasn't been paid to you, what's the amount? And make them shorter. We each have about 3,000 cases. I touch 60 to 75 cases every single day. I need to make very quick decisions. I need to decide whether I can help these people or not. I need to decide whether there's something really here or not. We cannot set hearings in every single motion because there's just no time. So be short, concise, and ask what you're wanting. Ask what you're, put in there what you're asking for. Evidence. Okay. When you come to court, I can consider things that are given to me in the courtroom, not your phone. Don't give me your phone. Don't show me your phone. Don't wave your phone around. Don't say it's right here on my phone. Whatever you have on your phone needs to be printed out. Whatever you want me to look at needs to be printed out. And usually it has to be provided to the other side ahead of that hearing. Particularly if there's a lawyer on the other side, you need to send them copies of what you're going to show me. And then you have to show up with physical copies of these things in the courtroom. Here's the pictures. Here's the bank statements. Here's the printed out text where they were nasty to me, whatever that is. If you have a video, the video needs to be on a thumb drive. We don't use the little discs anymore. We don't do that. And the clerk has to put a physical thing into evidence. So videos have to be on a thumb drive. Filing something is not evidence. You can file stuff all day long. That is not evidence. Evidence is only what is provided to the judge in the courtroom at the hearing. Along those lines, don't send emails to the judge's office with what you're complaining about, what you'd like to see happen, who's doing what wrong to whom. Don't do that. The emails to the judge's office are only to schedule hearings. If you have a complaint about anything, it needs to be filed in a motion. It needs to be filed in a motion. Next. All right. I'm just giving you a 2-minute hearsay. The lawyers take 3 years to learn this. And by the way, they don't learn it all that well, to be honest. But here's what you need to know. You are not going to be able to tell me what your children told you. You're not going to be able to offer a police report in evidence. You're not going to be able to offer a DCF report in evidence. Those are all hearsay. Any lawyer on the other side is going to say objection. You need live witnesses. Letters will not do. So the problem that people don't understand is, like, the court is not like regular world. In the regular world, you could say, like, look at this police report. Look what happened. No, in a courtroom, you can't repeat what other people say, even your children. That's very difficult, but it means you've got to have live witnesses to come in and talk about your story. The judge is not going to want to know the full history of your 5-year horrible relationship. We've heard it all before. We understand it's bad. You wouldn't be in a courtroom if things were lovely. We get that. We just want the very essence of what the dispute is and what it is you think is going to solve it. Our concern is your children. Our concern is that even though you all have selected maybe not the best person to have babies with, you did, and now we're all stuck with it, and you're going to be parents together for a very long time, and we want solutions. What would work? If meeting and exchanging in that place doesn't work, what's your suggestion? We want positive opportunities to give you a new way of doing things, but you've got to come in with more than just complaints, because we hear complaints all day long, all day long. There are 5 numbers needed for child support, essentially. If you do not have a case with the Department of Revenue and you're doing your own child support litigation and you're filing your own motions, your own paternity petition, your own divorce, your own request for child support, keep in mind we need income, pay stubs, tax returns, those kinds of things. We need health insurance and the breakdown. What are you paying for you? What are you paying for the children? We need daycare expenses and we need overnights. Those are the important things that go into this calculation. When it comes to time sharing, I look at who's the most reasonable. We have a bunch of factors. You can Google online, time sharing Florida factors under 6113. You'll pull it up and you'll see every single thing that the judge has to look at. I want reasonable people. If you're the most reasonable, you're probably going to get closer to the result you want. If you're not reasonable, you probably aren't. Fathers and mothers, once paternity is established, are equal. Equal. That doesn't necessarily mean 50-50, but it does mean that you are treated equally. So being one parent or another, one gender parent or another is not going to get you a leg up or have any effect on the proceeding. Being reasonable will definitely have an effect. I'm going to talk about a couple of the specific questions. And again, I'm just going to give you, I'm just going to give you hints about a few of the questions that came up. I'm going to stop sharing there. The child support for a child who's 18 but still in high school generally should continue until that child finishes high school as an 18-year-old. But you do need to file the motion generally prior to them turning 18. So you need to file that motion ahead of time unless the final judgment indicates that it's going to continue on. Modifiable is a word that relates to both child support and time sharing. But in either case, you have to file a supplemental petition for modification, and you have to allege a substantial, meaningful, big change of circumstance that is permanent. If you don't plead that, you're going to get your petition dismissed because it's not sufficient. If it is sufficient, you need to have it served on the other party and move forward with that modification action. Discovery in child support cases, we've kind of talked about a little bit. There was a question in the chat about hiding income and how you prove people are hiding income. This happens a lot. And sometimes I look at people's financial affidavits and I think this just doesn't make sense. They claim to make $800 a month, but they're spending $4,000 a month. That doesn't make any sense. And they don't have any credit cards. That isn't possible. In that situation, you say to the judge, they're spending $4,000 a month. So obviously that's what they're earning. And I use that number all the time. So there are ways to do that. You'll also get an opportunity to question that person during your hearing or trial. And you can ask about trips made, houses bought, vehicles owned, and just show the judge that they're not, that it's not credible. Alimony, that's a huge, big area that I'm not going to go into, but I will tell you that if you want to know what a judge has to look at, Google alimony Florida statute, and you will get the list of every single thing the judge looks for. And that when you have that, you'll be able to go into the hearing with evidence and your testimony and witnesses that go exactly what is that we're supposed to look for. There was a question in the Q&A about a paying parent that is soon to be out of jail, or a situation that's changing that would allow somebody to pay more or pay less. Again, that's a supplemental petition to say, hey, judge, something's changed dramatically and we want to get back in front of you to talk about this issue. There was a question about cases that are stalled, and I don't know the details around that, but I would tell you that every single motion that a pro se litigant files is delivered to the judge within 24 hours. So those motions, if they're clear and concise and you can figure out from it what's going wrong and what you need to have fixed, should be set for hearing, as I said, within 30 to 60 days. There are times when litigants don't do everything they need to do and the case gets stalled out. For example, we might enter an order that says you have not done your parenting class, you have not filed the notice of related cases, you haven't filed the UCCJA affidavit or whatever. You might get an order and maybe you fix one of those things. If you don't fix all of those things, the case just lays there. So you need to file something that says, I don't know what I didn't do, or I don't know why this isn't moving, or motion for hearing, or something that gives us an idea of that you don't understand what it is that still needs to be done. And then we'll enter another order to provide information to you about what needs to happen. I thought there was one more. There was a question about paternity being established, and DNA is not the only way that paternity is established. If a father is on the birth certificate, they are presumptively the legal father, and at some point that will legally establish you as the father. If you're married and have a child during the marriage, then you're presumptively the father, and that will be legally established at some point. If a putative father files a paternity action and the mother is served and doesn't respond, at some point there will be default and he will be established as a legal father. So there are different ways to go about that. So be short, be clear, and have your evidence with you when you come to court. Those are the best hints I could give you.
All right. Thank you, Judge Diana Tennis. So how often do you get that, a judge answering questions? And we've got a lot of them here. So that's going to be the next portion of our legal forum here, was to go through the questions. Now we've had 34 come in now. So and they're all in a different order, but what I'm going to do is I'm going to go through these, Judge and the rest of our panelists, in order so we can kind of nail these, maybe even just a short answer. So the first one that came in was this question about, my daughter turns 18 next week. Child support will stop. Is it possible to get him to pay since she's still in high school and going to college? Judge,
Yes.
address that. Short answer.
file immediately.
Okay. All right, second question is a two-parter. So this is a long one. Let's see what we can do with this. The person in the forum says, I've had an active case for 10 years, was originally opened in Polk County where the ball was dropped. Case should have been done. Administrative route, which I was informed when I relocated to Orange County. The other parent owns a legal business in the state of Florida, pays taxes, and owns a home in Duval County. Sheriff's office identified the tags of the cars in his driveway, registered to him, but his wife or girlfriend opens the door, states he doesn't not live at the residence. Every 4 years, my case is closed. I have to go through the entire application process. My case has never moved forward because he can't be served. What more can the state of Florida do? It's a major loop while that the other parent's aware of and will continue to avoid it because it works for so many years. My son will be 17 this year, and it looks like I'll never get any support and I will not be able to get back from the initial case 10 years. Any answer to all of that would help?
It sounds, when they say the state of Florida, so this sounds like a specific DOR question.
Mhm.
We, through the state of Florida DOR, those cases, more often than not, will send service of process through the sheriff where we have an address. The more addresses we get, the more times we can try service. If that's not possible, there are other options. But I will tell you that the state of Florida's resources are limited. And so when it comes to what you see on TV, what you see as far as service of process and tracking people down and investigative services, you may want to consider using what's out there in addition to what the Department of Revenue provides. I have seen a handful of cases where that partnership has yielded something better, but unfortunately, without looking more at the specifics in that case, you've got a lot of counties involved, you've got a lot of people moving around. It would be difficult to really answer. But what I will tell you is that there is something called substitute service. So it doesn't matter if there is an adult who resides in that same house with the person that is trying to be served. If that person is over the age of 15, we can have substitute service affected and the paperwork gets to where it needs to go and the case moves forward. So long story long, there's a lot of moving pieces there. So it would probably be better off looked at on a case-by-case basis, but that substitute service is a possibility.
Yeah, and the only thing that I would add to that, assuming this is a Department of Revenue case, there's a lot of things going on that I would like to have a chance to take a look at and do it in a way that would allow us to do the research and provide you, what's going on with the case and what we can do to make sure that the actions that need to happen, and service can be a challenge at times, but there's ways to overcome service issues. Private process is always an option. So I would encourage you to reach out to me through the email that's going to be provided, and somehow put in the subject that this question is related to the Clerk Russell's community forum. And I will ensure that not only will I respond back to you acknowledging receipt, but we will get you in contact with the right managers in, I guess it would be Orange County, and kind of chart a course forward on making sure that we get compliance with that case.
Thank you, David. So can you give that email address? You want to share that? How can we share that with
Yeah.
everybody?
Should I put it into the chat?
No,
I'll just drop it in the chat.
if you could just share it with us verbally.
Yes.
First of all.
It's David.Gillen, Gillen, at floridarevenue.com. David.Gillen, Gillen, at floridarevenue.com.
Okay. Great, thank you. On to the next question. So next one, can I modify child support for current child since I'm disabled now? Get food stamps because don't get much in disability, can't afford modification. She was an RN and the child support was $700 for 2 kids based on estimated salary. Now I can't work. Daughter number 1 will be 18 next week. Won't be paying for the next month, so it will be just $350 for 1 child.
So this is another situation where we would want to look at the numbers. we would want to make sure that we put the numbers into the guidelines and make sure that there is a substantial change in circumstances. If you're receiving disability, that is something that could qualify for a modification. But again, you want to make sure that you get in touch with the Department of Revenue so they can review your case and put those numbers in and see what's what.
Great, thank you, Annie. Okay, next question. How does a parent get the attention to the case or have case audited by judge or clerk, since DOR is not auditing or taking any action after years to reset a trial date to get a court order for support?
Well, I'll share this. Everyone here is human. Everyone in this process is human, and technology only works so much as we work with it. So it's probably something that you've identified that's fallen through the cracks. And if it's not, it's sitting on someone's desk. And we just have to be good advocates for ourselves. You're doing that by being here. And so I would take down the email address and make sure that it gets the attention that it needs, because Judge Tennis was talking about how you file that pleading, that motion, that petition, whatever it is, and the system kicks it to somebody else. And if that particular pleading is kicked to 3 different people and each person thinks the other one is dealing with it, then it's going to get lost. So just like we have to do in every other aspect of our lives, we've got to make sure that we're touching base and making sure that item's being seen. So I would encourage you to reach out to the department if it's a DOR case, or if it's not, because there are those cases out there too, reach out to the judge that it's assigned to.
Yeah, and I would like to add, I think it is a DOR case, and the clerk's balance is the official record. So we do try to match our balances with the clerks, and we do audits to reconcile those when there are questions. So I would, in addition to what Annie just shared, and she also encouraged you to reach out, I would also send an email, and I can look into that and find out what the issue is regarding the balances and how that's affecting the next step actions that might need to occur on the case.
Great, thank you.
I want to elaborate on that as well, Dane, sorry.
Go ahead.
If they want to, they can also come here to the Clerk of Courts and fill out a request to have their case audited as well. So they can definitely come to room 315, fill out a request, and then we'll assist them from there.
Great, thank you. All right, good information. Our next question. What is the process to file for discovery in a child support case, i.e. income tax forms, lease agreement, bank statements?
So that's actually pretty simple. You just go down to the clerk's office. You can get a form. You can go to the self-help center on the 3rd floor, and they will give you assistance and forms, and you just file a motion that says motion for discovery and just list everything you want, and then file it. It'll go to the judge. Most of the things that you're talking about are required anyway. So if I got that motion, I would enter an order going, yeah, granted, they've got to provide it anyway. And I'd give them a certain amount of time to provide those documents. I'd probably do it both ways, because you both have that obligation to provide those documents, but that's absolutely reasonable and absolutely an okay thing to do.
Yep, thank you, Judge. Okay, defendant, father of 3 children, claims to not be working, but I believe he's making money under the table, especially because he lives a lavish life. How do I prove this?
So I talked about that a little before, and sometimes it's difficult. But I look at the financial affidavit and what they claim to be spending and what they have and assets and lifestyle. I do believe, when you have a child support enforcement action, you can go 2 ways. You can go to the court yourself and file your own motions, or you can go through the department. The department does have some tricks and ability to get information that the judges don't. So if you came to a hearing in front of me for child support, I can't do fancy liens. I can't do that. And I also don't have access to their taxable income last year. You'd have to figure that out, get that from them out of discovery. So the department does have some ways to find out information and to enforce things that are special. And so that's something to consider when you decide which route to go.
Annie, I actually had a question. As some of our customers have gone to court for contempt, they have allege that they bring printouts from Facebook and other social media with the other parent holding large sums of money and being in front of fancy vehicles. Is that proof?
So that is actually, I was coming off mute to mention that, going back to what Judge Tennis mentioned, if you bring it on your phone, if you have photos and screenshots on your phone, we cannot use it. And when you bring it printed out with the web address at the top, it can be authenticated, it can be used. It can be used in a number of different ways, especially if you catch them saying one thing and you have evidence, photos or screenshots that shows them doing another thing. I believe I saw in a question maybe later, but about having a business. If you have a business and it's registered and you can bring that registration with you, screenshots of that, printouts of that information is also assisted. But I have to go back to what Judge Tennis was advising, or her tip or trick: print it out, because if you don't print it out and bring it with you and bring some copies with you, we can't use it.
And Sherry, something I think that is related to that is during the pandemic, we stopped, essentially for a year and a half, I stopped putting people in jail because the jail was just such a hotbed for COVID. And I just didn't feel good about doing that. And everybody's life was disrupted and their work was disrupted. And we were all on, kind of survival mode. That is over. I'm here to tell you that is over. The family judges are, have been told that we were soft on crime for a while. That is no longer the attitude. So we are putting people in jail. If you come to court on a contempt motion in front of one of the circuit judges, the payor, the person who's supposed to be paying who isn't, is presumed to have the ability to pay. They have to prove they can't pay. And if they don't do that, then we're going to find some amount that they can pay, and they're going to go to jail until they pay a purge. I will just say from personal experience, 8 years on the bench, 30 years in family law, I've gotten some enormous amounts of money out of people who cried poor. So I think that we're a little bit jaded about that. We're going back to the jail route, and I think people are going to find enforcement actions have a little bit more teeth these days, after we've all get, we don't have to worry about everybody catching COVID at the jail.
Okay. All right, moving on. Thank you. Great information. Next question. If Department of Revenue has your case, however, it's not enforcing because other parent has brought them proof of being disabled, yet has a disability income and has not included child in that, what can the parent receiving do with failure to pay? Anybody can help with that one?
I'll try, and I'll ask Sheree to come in behind me. This is kind of a tricky question to answer because we don't know what kind of disability that we're talking about. So there's some types of disability that you can offset, and there's other types that you can't. Being disabled is a legitimate reason not to be able to pay child support potentially if it's full disability. So I think that the best way to approach answering this question, since I think we need some more info, is to contact me, and we will look at, I'm assuming this is a Department of Revenue case. If it's not, I'll still look at it and try to get you some general information on what the options might be, if there are any. Sometimes we do have options, sometimes we don't, but the disability questions can be unique based on the type of disability and the amount of the disability.
That is definitely true. As David mentioned, I just wanted to put my email address. I'm probably going to change my presentation name just so you can see that, but you can also email any inquiries about any Department of Revenue cases. You can email me directly at Sheree, CHERI.Wright, WRIGHT, at floridarevenue.com. And we do review. It is a priority. Anytime we get a request from any of our customers, potential customers, past customers, whatever it is a priority. So please reach out. There are a lot of different ways that this disability could go. So I don't want to misinform anyone.
And I would mention, if by chance it's Social Security disability, you as the parent who has the child may have some work on your end to do to apply for whatever derivative benefit. So I'll mention that that's different from VA disability, SSI, that's different. That's why we're making sure that you know that it's a case-by-case basis. But if it's Social Security disability, I just wanted to mention that there's other work that needs to be done there to make sure that you get what's credited to the child.
Okay. We're going to try to power through here. We've got still about 30 questions. We're hoping to get to everybody's question. If not, again, we've got contact information here for David Gillen and Cherie Wright and at the clerk's office. One of the questions I want to answer up front was we have been asked if we could provide this recorded presentation. Well, you can get this recording on our website, at the Clerk of Courts website. We will be posting it there and also on our social media channels. But the easy way you'll be able to access all of this after we're done tonight is our website, which is myorangeclerk.com. Okay, next question. My two daughters' dad has been incarcerated since 2012, will be released soon. How do I establish child support once he's released?
I'm curious about whether she means establish or reestablish. In either case, you'd need to file something. If there was an old child support order that has been abated because he was in jail, that happens. You'd have to file a motion to unabate, potentially maybe a supplemental petition to modify, if depending on whether you want to go back to the old amount. If it's a brand new case, meaning you've never filed before, if you could do it yourself as a petition. Or I'm assuming, Annie, they could ask the department for assistance.
You're correct, they could. Simply put.
Okay. Next question. I have become disabled due to a car accident and I've been in compliance for 9 years, paying $858 a month. I am not currently working and I applied for disability due to my condition. I'm afraid I won't be able to afford my current order. What services are available for me?
Well, I think it's the same answer. You file your own supplemental petition for modification, or you ask the department for assistance and Annie's office will help you.
Great. Next question. I'm separated from my husband for 4 years now and just had a baby, but not with my husband. Will I still be able to get support from the father?
So that's a really complicated question. So I'm going to talk in generalities. Generally, a husband is deemed to be the legal father. If the biological father is on the birth certificate and everybody accepts that that's the biological father, then you should be able to disestablish your husband as the legal parent in your divorce action, which maybe is a touch overdue. And establish the biological father as the legal father in a paternity action. So it's complicated, but more and more of those situations are happening, and there's probably a way to have that be done.
Okay, thank you, Judge. All right, moving on. What will happen if the father doesn't comply with the genetic testing?
Well, if it's through the Department of Revenue and we have an order that orders the father or the alleged father to go to genetic testing, that the department will send out 2 appointment notifications with different dates and times, again, to that address that's of record. So you want to make sure that you update that. And like Cherie was saying, open your mail, because if you don't open your mail, you're not going to know when your appointment is. Then what happens is you go to your appointment. If you don't go to your appointment, then we move for sanctions. It's called a motion for sanctions. If you show up and you say, Judge Tennis, I'm so sorry, I missed it because whatever, then you might get an opportunity for another genetic testing appointment. If you miss that one, then we're going to request that you are adjudicated the father by default. And then we move forward. So you can't just ignore it, but we can move forward by default and find someone to be the father of the child or children in the case.
Okay. All right, next question we have. Can a parent that lives in Florida establish child support for a child that lives in North Carolina?
So that's there are too many details about this that I don't know to be able to talk about this, but if the paying parent is in North Carolina with the child, sure. I just there was just a lot of information I didn't have.
I'd venture that there's always a way to establish child support. There are just a number of different factors that you're going to want to talk to somebody either at the Clerk Self-Help Center or at the Department of Revenue to help you navigate that. And the Department of Revenue, the state of Florida, communicates with other agencies in other states, like you heard before, and they can assist you in making that happen. So if that's sending the case to North Carolina to happen there, or getting information for the case here, it can happen. So you have, just because you live in different states doesn't mean that it can't happen. You can get that child support order.
And just to add, in relation to interstate cases, speaking strictly for the Department of Revenue, our mechanism to communicate with other states is an internal system, and sometimes it just does take a little while. So interstate cases do tend to move a little slower than a case that both parties were in Florida. So I just always like to put that out there when you are interacting with the department and you have an interstate case. And we encourage you follow up, check status, but be aware that they have months before they actually are required to get back to us. Not to say every state takes that long, but just be mindful of that. We need a little time.
Gotcha. Okay, thank you. Okay, how are other parents served? Is it just in person by the sheriff? Question mark, no calls, no certified mail with signatures?
So certified mail is not service under any of the statutes that require service, but it can be substitute service, as Annie talked about before, a co-resident. And it can be an affidavit of diligent search, and we did our best, and service by publication. But generally, no, certified mail would not be considered service of process.
For the Department of Revenue and our admin cases, we do utilize certified mail service. We absolutely, we utilize that. We can utilize subservice, as Annie mentioned before, but we do definitely accept it. And if somebody is willing to be served, we also have our affidavit of hand delivery. You are welcome to come on into the child support office if you want to be served. We can do that for you. But yeah, we do sheriff, admin certified mail, subservice, any way possible, hand service, all of that.
And then on cases where the order is already established and we're trying to get compliance, that service is completed through mail. It's strictly mail service, regular U.S. Postal Service mail, and that constitutes service.
Okay, thank you, David. Thank you, everyone. All right, next question. I'm on child support currently. I have an $88 balance. I do have a case pending for shared custody. The case has been pending for almost 2 years. I've done the mediation. Other parent did not show up. Have yet to get anything established through the court.
File a notice for trial. That's what prompts everybody that you've done what you can and you need a court date.
What's that again, Judge? File?
A notice for trial. Now, unless the department's representing you, in which case call the department, but if they're not, file a notice for trial.
Okay. All right, next question. I have a paternity case that has been pending for the last 2 years, and the other party refuses to go to court, and she's been served 3 times. I've exhausted all my options.
So the weird thing about that is the service 3 times doesn't make any sense to me. So that's a quandary. If a default has been entered, file a notice for trial. And if a default hasn't been entered, I don't understand. File a motion saying I'd like a hearing to talk about what I'm doing. I don't know, but if a default's been entered, file a notice for trial.
Okay.
Yeah, and if this is a DOR case, I don't think that it is, but if it is, reach out to me because we need to take a look at what's going on with the paternity establishment, and we can let you know what needs to be done and what's pending and what we're going to do to accomplish that.
Yeah. And David, again, I'm going to give your email address. It's david.gillen@floridarevenue.com. Okay, next question. I don't think I ever got credit for overnight stays. Can I recover credit still?
So you could file a supplemental petition to modify your child support based on the fact that you now have substantial overnights, but it will only be modifiable back to the date of the filing of the petition. So I guess I would say file that supplemental petition.
And it depends on how many overnights. So if it's like Judge Tennis just said, if it's substantial overnights, you're going to get credit. If it's one overnight once a month, probably isn't going to move your child support amount.
Great, okay. And thank you very much. We're going to move on to the next question, but just to let everybody know, at the end of this, we're going to put the contact information up for David and for Cherie at the Department of Revenue. And we'll also inform you of how you can get in touch with the clerk's office as well through our website. So next question is, how do I get my case heard in front of a judge? I do have one pending, but nothing took place.
I'm going to assume this is not, that the department is not enforcing child support in this situation, and this is in front of a judge. And I guess I would say, we don't know about a case. There's 3,000 of them just lying there quietly sleeping, as far as I know, until somebody files something. I go, oh my gosh, you know, this something needs to happen. So file a motion to tell me what I need to do next, notice for trial, when you file something, we see it. If you don't file something, it's just one of 3,000 cases that we're not spending our days thumbing through. So that's what I would say.
Okay, thank you. Very informative. All right, next question. Can paternity be established without genetic testing?
Would say yes. You can admit to being the father. You could just show up and say, hey, yes, I'm the father. I don't want DNA testing. I know it. As Judge Tennis said before, you can acknowledge paternity on a birth certificate. Then after a certain period of time, you're the father that way. So there are ways to do it without getting a DNA test.
Okay. Next question. How do you enforce a permanent alimony judgment via IWO, income withholding order, in which the payer has retired? Motions for contempt have all been dismissed.
So an IWO goes to an employer. So if there's no employer, essentially there's no IWO. Now you can get a judgment as to what the amount is owed, and there are ways to enforce collections on that judgment. Frankly, you're probably going to need a lawyer involved for that, and they can go after property, they can lien things, they can go after bank accounts. There's a variety of ways that any creditor can go after a debtor. But it gets much more difficult for a judge. Now, I know nothing about your situation. I will tell you, if a judge has said 3 times, I don't have enough evidence that they can pay to hold them in contempt. That bodes ill to me. But there may be civil remedies through a lawyer that may be willing to take the case for a part of what they can collect. That's a bad situation. Keep in mind, if the other person dies, their estate also may well owe you your arrears. So there's, that's an option also, potentially.
Okay.
Sorry, there's not better news.
Mm-hmm. Okay, next question. Are the liens on private cases only or on all? Liens on private cases only or on all?
If they're talking about liens in regards to this one, if they're referencing the judgments, when a judgment is put in a case, it's only on private cases. It doesn't apply to the Department of Revenue cases.
Okay, thank you, Jennifer. Next question. Can the judge default a non-parent without paternity test?
Yes.
Yes, if you do not participate, that is what we ask for. You got to participate in the court proceeding.
Okay. All right. I apologize. I missed the info regarding bank account freezes If the NCP has a joint bank account with their spouse, can the account still be frozen?
Yes. But we do have a system in place. It's called an injured, well, not really injured spouse, that's for taxes. But the department, because we do cast our net so wide with our enforcement actions, we are very much aware that people move on. They have new lives. There are other ways and other things for them to make a living. So if we do take an enforcement action, we have, most times we have an internal system to correct it. So with the bank account, if our NCP or if our parent paying support is the primary on there, we will freeze it. But that parent, that NCP's new spouse, they can provide us documentation showing what monies is theirs. We can take that portion, that money out of that bank account so that they are not negatively impacted. And we also have the same mechanism in place for tax returns. We realize our parents paying support have filed with their new spouses, and obviously their new spouse is entitled to a portion of that refund. We have a system in place to get that money out as well. But yes, we do intercept that.
All right, thank you, Cherie. All right, next question, is there a way to verify that an income deduction or income withholding order is being carried out by an employer?
I'm not too sure if there's a way to verify it. Typically, the income deduction order, when it's filed on the case, any one of the parties can come and they can get a copy of it and they can take it to the job, the payer's job. And from there, that job will go ahead and start initiating the payments. For me, I would say the only confirmation is once we actually start receiving the payments.
Jennifer, could they call the SDU, this state disbursement unit? Would they be able to say like, yes, this is happening? Or we're receiving funds from the employer? Would they be able to tell them that?
They wouldn't be able to get that information from the state disbursement unit. The state disbursement unit can only tell them if any payments have came in and been dispersed, but that's it.
Not where they came from. But I mean, so generally an income deduction order gets entered, and just in my experience, 30 days. And if it's not, clicking in after that, then either somebody didn't give it to the employer or the employer didn't read it right, or something's gone wrong, generally, I would say. And then you could file a motion that says, hey, IDO not working or something, and try to figure it out.
Well, David, do you want to answer this?
Well, I'll start and you can finish up. But the as far as the Department of Revenue cases are concerned, we would automatically follow up with an employer if the deductions did not start. Our payments are coded as that when they're received via income deduction, they're coded that way, so we know if it's a payment that was received via income deduction. And once again, we have review steps built into our computer system that would trigger a review if payments were not received, and then we would follow up to find out what's going on.
Can I just make a point, an aside about that? This happens all the time, that the pro se folks will come in for a final hearing, and their final judgment will get entered with a child support amount in it that is supposed to go through the state disbursement unit in Tallahassee. And the order will have the instructions on where to send those checks, but the person won't think about that, and they'll just be waiting for the income deduction order to take effect, and they'll keep making the payments directly. And immediately they're going to have a delinquency, and the clerk will send you a delinquency notice. And if you don't do something right away when you get that delinquency notice, then there'll be a judgment against you, and it becomes a big brouhaha. So just keep in mind, child support is generally paid through the state, and you have to pay it through the state if you're the payor until the IWO goes into effect, or it causes these like cascading problems that are kind of a mess to undo.
Our computer system at child support is set up to automatically search for new employers. And essentially, if somebody has a new job by that second paycheck, we have identified that. But as you stated, Judge Tennis, yes, until you see it coming out of your paycheck, make the payment, send the payment in exactly where they 85 PO Box 8500, send it right exactly where it tells you to go. Even though, yes, we are aware that you have a job and you are aware that we're sending an income deduction notice to your job, that's still 2 to 3 payments that you could have received from your employer that we would not receive. And instantly you have a delinquency, instantly.
All right, lots of good detailed information. Moving on to our next question. I have a question about a case that has been open over 2 years that I have asked to be closed since it has been no action over all this time and have not been answered over a long period of time. What can I do? That's probably a difficult one to answer.
There's some information that's probably, I think it's maybe is missing to this question. I'd have some additional questions to go with that, but just to generalize it, if a case is open and it has not proceeded after some time, they would have received a letter in the mail from the court or the clerk informing them that the case is most likely going to be dismissed after a certain period of time. In this case, if child support, to me, it sounds like child support has not been established and they're just trying to close it out. They can file a motion to close the case.
It's true. What?
Okay.
They can do that whether it's a DOR case or not a DOR case. You can file a motion to close the case. And if the Department of Revenue is still enforcing it, it'll go to a child support hearing officer. And if they're not still enforcing it, it'll go to a judge like me. And we'd figure out whether it needs to be closed.
Gotcha. Okay. Moving on, does 50-50 custody mean that the father does not have to pay support?
I am so glad you asked this question. This is a fabulous question. And the answer is no. So child support's based on a formula, and the number of overnights is part of the formula, but that is not the entire formula. So all of those other numbers still get plugged in. The number pops out. It is what it is. So no, that doesn't have any effect on the actual number. In fact, there are times when somebody may have more overnights, not just 50%, but 60%, and they could still end up paying child support because they make significantly more than the other parent. So that doesn't, it is part of the equation. It's not the whole equation.
I've
Okay.
seen a case where they've been ordered to pay over $800 a month. I've seen a case where they had to pay $38 a month. So you really never know. Judge Tennis put up those 4 important things: income, health insurance, daycare, and time sharing. So it's all 4 of those.
Okay. Next question is, what is an arrearage affidavit?
So an arrears affidavit is a document that determines how much back child support or arrears is owed. An affidavit is a statement certified by the clerk's office and will be used in legal proceedings to determine child support.
It's also presumptively correct. So if you come to a contempt hearing in front of a judge and we say the clerk's office says you owe $10,000 and you say, no, 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 no. Well, you need to go down and get the printout from the clerk and go through and figure out what payments they missed. And I have to admit that it's generally like the bank. Every time you think they're wrong, they're not wrong. They're not wrong very often. And usually if they are wrong, it's because a judge has written a really bad order and it has gotten them messed up. But those arrears affidavits are very important and we use them all the time.
All right, thank you. Okay, next question. Can I still get support if I'm still married but have been separated from my husband for 5 years but have a baby that is not my husband's?
So go ahead, Judge Tennis.
No, you go ahead, Jennifer.
So once again, this is a broad question. You can, I would say, to apply either through the Department of Revenue or here at the clerk's office, and there are possibilities to this. There are ways around this.
Yeah.
Okay, next question. I have a question about a custody order by extended family that is left open over about 2 years that a motion was filed to have it closed, and over about 6 months it has not been answered. There's not been any motion over this time except asking for it to be closed. Sounded like a similar question we had earlier.
So I do get a lot of, so temporary custody orders, there's a lot of litigation about those in our courtrooms. And I would just say, I'm assuming this is a temporary custody order by an extended family member that we're talking about. Those are never closed in the sense of permanent. They are not permanent. They are always temporary. A parent who consented to an order of temporary custody can always come back and say, I am now okay to parent. And if there was no finding of unfitness, it's just that easy to make those go away. Even if there was a finding of unfitness, they can come back at pretty much any time and say, I'm the biological parent and I want to be parent again, and I've got my act together. So those are very, they're not very strong orders, and they're not meant to be permanent. So if that was the question, then that's the answer. If it wasn't the question, I'm sorry.
Okay. All right. We might be getting close to getting through all these, but next question. What if the father, parent or unmarried, works under the table, has never paid support, sees child once or twice a year? Child is 5 and living with her mother and grandparents who have assisted mom with her support since birth.
So on this one, I didn't really grasp the question that's being asked. If they're trying to establish child support, once again, they can go through the Department of Revenue, or they can come here to the clerk's office and open a case with us.
You could go back 2 years prior to the filing of the petition.
Okay. Next question. What if my spouse hides income information and as a result, it reduces the child support payment?
Sometimes, you know what, this is going to happen. I can't tell you that this is always going to be solved. I'll be honest with you. If you can get witnesses to come in and talk about lifestyle and spending, if you can point out problems with their financial affidavit, or that what they're saying they make doesn't match, you can have people testify that know them. Maybe you have experience and you know what they made, and when you were together, and you could testify about what they brought home. Pictures, things like that can be helpful, but those are very difficult situations. I would have to tell you, I often tell people, like, be very careful about who you have children with. Be careful.
Yeah, the only, I'd just like to add, we hear this is a common scenario that arises with the parents who were supposed to be receiving support and concerns they have about whether the parent who owes support is being truthful about the finances. We have a number of ways to verify assets and ability to earn and all that stuff. It's not perfect. And if somebody wants to hide, they can hide it. It doesn't mean that we're not going to stop trying to prove what the assets are. And over time, and it may take some time, we'll get to the identification of it. But there just has to be a level of patience as we work through that. We're not going to give up on it, but it's not as easy as pushing a button and something pops up and we have the information. It's much more involved with that sometimes when somebody is very, very strategically trying to hide assets.
Okay, thank you. Yes. Next question. Can sole parental responsibility be awarded if a default judgment of paternity or divorce is entered?
Yeah. If you go to that final default hearing and there's evidence that the other person is just not engaging at all with you or communicating with you, and there's no way for you to do shared parental decision making, yes. I will tell you, though, on a default situation, the law generally also requires the court to reserve as to a parenting plan in the event the other person wants to say, hey, I'm back in the picture, I want to be involved and I want a parenting plan. So it may not be a permanent forever thing, but yes, that does happen.
Okay. Next question. I never signed a birth certificate, but was declared the father without paternity test. How does that process work?
Sounds like a default, Andy.
I was going to bring us back to that. Sounds like we tried and it was a default. You didn't answer, maybe you didn't correspond with the court. You didn't say you wanted a test. You didn't show up. There's so many ways that could have happened because you didn't engage. somewhere along the way you stopped and we kept the train going. We kept the case going to try to get child support.
Okay, great, thank you. This next question is about, is the information the same in all counties, or is this just specific to Orange County?
Related to the things that I've said about the court process, this is probably generally accurate across the entire state. I don't think I've said anything that is particularly Orange County centric.
I would assume the same thing with our DOR.
Yeah, everything with DOR is going to be uniform. Obviously, there's some unique things in processing that could occur at any county level operation. And you can go into any child support. I mean, you can literally access your child support, get support for your child support from anywhere in the state. You could be in Pensacola, your case is in Miami. You don't have to go to Miami. There's all kinds of ways for you to get assistance with your case, no matter where you're at. You don't have to be there in person unless there is a court hearing that's required, but all the other stuff can be done virtually.
I will share that my perspective has been Orange County because we are attorneys. My law firm is just Orange County specific. A lot of the general things that I've mentioned are the same in other counties, but I will mention that there are local rules that govern our Ninth Circuit that might not be the same in other counties. So you just want to make sure that you go to, they all post them on websites these days. You might want to make sure that you go to those websites and check out the local rules if you're looking at another county.
That's excellent advice. We do have specialized rules. Every single judge has a page on the website at the ninthcircuit.org that has their policies and procedures. And there are orders that you will get in family cases in Orange County, in Orange and Osceola, that you would not necessarily get in other counties. That's absolutely accurate.
Okay. We have about 10 questions left we're trying to get through here. So if we're trying to answer these, any other questions, we will try to basically give you the contact information at the end of this webinar, and you can reach out to us with direct questions from there. So the next question is, what are the factors a judge considers in a shared custody case when parents do not agree? One parent desiring 50-50, the other desires 0 or 70-30.
So this is going to be very general. If you Google Florida Statute 61.13, you will see all of the things that we look at. Number one is reasonableness. So if you work a schedule where you're working until 2 in the morning and you live an hour away from the child's school, 50-50 isn't going to be reasonable. If everybody lives close together and everybody's had a lot of activity with the children and is capable, then a 30% schedule or every other weekend is also not going to look reasonable. You're going to be forced to go to mediation. The mediators are very experienced and they can't tell you what to do. They can't give you legal advice, but they can give you some impressions as to whether or not what you're asking for is likely to happen in a courtroom. This is an area that I find people are very often either not realistic about what they can do given their circumstances and schedules and location, or they're not reasonable in them wanting to hoard time and keep the other parent from having substantial time sharing. So it's definitely an issue.
Okay. How is DOR able to suspend license of child support not paid due to hardships? And can you get a work permit to work and continue full or partial payments?
Well, I'll just start the answer, David. I'm sure you have some additional comments, but as far as getting a driver's license because you have gotten behind for whatever hardship reason, here in Orange County, there's a certain philosophy that, we share with the inmates that we provide outreach presentations to. And there is a program, it's called Linus. And basically it is just an awareness and an understanding that some of our parents have had some hardships. They've gone to jail, they've lost their job, they've had some type of medical setback. but they have experienced some type of hardship that has prevented them from getting a job, maintaining a job, and paying their support. So if somebody is freshly released from prison or might have just been released from some other institution, could have been medical or otherwise, and they do not have a valid license and they want one, we ask that they speak to us. We just ask that they contact the department, explain what has been going on, let us know what is going on in your present day and what your goal is. And we can work with you. We work with the parents. We work with our parents all the time because we realize nobody's winning when the child is not receiving a payment. No one. So we do everything we can to help that. Of course, we're not going to give that type of latitude all the time, every time, without the parents showing us some type of effort on their part that they're out there looking for a job. They joined some type of program to help either build their education or job seeking. It's if they show us that they're putting in effort, we absolutely will work with them so that they can get on their feet and get back to paying their support and get into compliance. David, I don't know if there was any.
Yeah, the only thing that I would add is, it's hard to say if there's a hardship, that's a broad term, but we will work with anybody that comes in and is having issues in paying their support if some sort of enforcement, whether it's administrative or judicial, has been initiated against them. The driver's license note, before you even get a driver's license notice from the department, there's multiple other delinquency notices and things like that already is an indicator there's an issue there. But then when you get the driver's license notice, it provides direction on what you can do to resolve that, including coming in, trying to arrange a payment agreement, which would allow us to stop that driver's license action from moving forward. We want our customers that are supposed to be paying support to have their driver's license. It's very important, and we're fairly flexible in making sure that we don't suspend it. If we do, that we try to figure out a way to work with you to get that license back. So I'm not sure what's going on with your case specifically, and feel free to reach out, and I'd be happy to take a look at it and give you some more information.
Okay, thank you. Real quick on this one, can Judge Tennis repeat the Florida statute she mentioned about time sharing? It started with 6.1.
It's 61.13. And you could literally Google Florida statute, best interest time sharing, parenting plan. You're gonna get to it.
Okay, next question. Can child support be deducted from VA benefits? VA benefits.
I feel like that depends. Anybody? I feel like it depends.
I'm sorry, I didn't see the question. But as far as department cases, depending on the type of the benefit, we may be able to garnish that. Service connected disability, we just can't touch that. So we would have to see the documentation and the information associated with it. But yes, some disabilities from the VA we can garnish.
Okay, we've got 8 questions left. So because we're running up our time, we're over our time, but we had so many questions tonight to get to. So hopefully, if you all are ready to power through, 8 left. The next question: how to provide evidence for virtual hearings? Do you prefer for evidence to be mailed to a judge or emailed to a judicial assistant?
I would say email it, but keep in mind that the clerk also needs a copy. So generally people hand deliver a copy to the clerk's office on the 3rd floor. You could do that also to the judge's office, but do it far enough ahead that they can get it to the clerk and then send us our copy electronically. That would be great.
And I'll reiterate that each judicial officer, judge, hearing officer, magistrate likes their evidence differently, and they have that on their website. And if you don't go to their website, they also will put instructions in the order for trial or in the notice of hearing. And when in doubt, the clerks know. They know their judges, they know their magistrate, they know their hearing officer. Give them a call and see if they can help you with what they like and what they don't like. Judges move around, magistrates get reassigned. So it's always going to be different. So don't assume that the judge you started with or the magistrate you started with is necessarily going to be the hearing officer you end with.
Okay, next question. One of my children is both shunt and G-tube dependent. My child does eat by mouth, but requires at least 1 to 2 G-tube feeds per day. The father has not been providing these feeds during their once weekly overnights for the last month and a half, despite the fact that this is listed as a requirement in the current temporary time sharing agreement. Will this affect custody time sharing should I choose to request a trial?
That's way too specific for me to comment on. I'm not going to do that. The judges can consider anything and everything that they believe is in the best interest of children.
Yeah. Okay, next question. I was arrested for non-payment last year. I didn't know child support was ordered. I wasn't on the birth certificate. I wasn't aware that paternity was requested or about a hearing. I found out that the judge defaulted me as the father. What can I do?
First of all, update your address, update your address, update your address. If that's the one thing you learned about tonight, please, please, please update your address. Because if you didn't know about it, it's because you didn't update your address. So I'll share that. Then what I believe you're looking for is called a petition to disestablish paternity. But without looking at your case a little bit further, I'm not sure if there are any other remedies there. You can always file a petition to disestablish paternity if you want a DNA test and if you think that you are not the father.
I would like to add just a thought about this. We've talked about defaults a lot. There's a rigorous process, checks and balances to go through to get a default order. And we're doing this because we have a high level of confidence that the information is being received by the parent who it's supposed to be going to. So I just want to reemphasize again, we are, especially with those, I mean, you're establishing paternity in a way that there could be questions. And that's why we go through the process that we do to, provide every opportunity, make multiple contacts so that we don't have to go down the default path. But we do it knowing that when we get to the point where the judge is going to enter the order, we feel confident that of all the information that we have and the notices that we've sent and what has not happened afterwards, it's resulting in us pursuing the default order.
Okay, next question. If I stop child support, how soon will it take effect?
And that varies. If they reach out to the Department of Revenue, it really depends on how long it takes for the process to be put through, and then the Department of Revenue has to reach out to us to remove them as I would say as basically the agency who's providing them with service. But after that, even though they come off of the case, a lot of times they still have to file a motion to terminate the service. So there are steps to that. So everything really varies. And especially when you're filing, like if you're filing a motion to terminate or any type of motion, it can take between 30 to 90 business days. So that really varies.
Just to reiterate what Jennifer said, as far as if you request your case to be closed with the department, we will close our interest in it, meaning we will stop enforcing your case. The order itself still remains active at the clerk of court. It's going to be there. And depending on what is said, the income deduction notice may even stay in place. So when someone asks for closure, we just want you to be very clear what that means. There is closing the case with DOR, meaning automated enforcement ceases because we are the moving agency and we'll stop all of that. But that balance is still going down at the clerk of court. The order itself is still in place. The income deduction notice could still be coming out. Now, I mean, we do have a system in place. We can stop the IDM, but you would have to be very specific if you want that done, and you need to let us know that. But yes, and how to handle it, the clerk of court. I'm sure you covered that.
Okay. Next question. What do I need to prove the number of overnights the children are spending with me?
Well, I mean, it's the kind of things that you would have to prove all sorts of things. Your testimony of people around you, people that live with you, people, grandparents, pictures, records from the school, who's checking the children in and out, softball coaches, this is who's bringing the child to play at night. I mean, you just think of all the people and eyeballs that touch you and the child over a period of time, and your testimony.
Okay. Next question, what is motion to enforce support order and set arrears?
That sounds like one of our motions that we love to file in our child support enforcement, especially with the hearing officers. In those cases, what we're asking the court to do is to take a look at the case and enforce the order. So that could be, most specifically, we're asking for an adjudication, that's a finding of whether or not the payor has the ability to work. And if that person comes to the court and says, yeah, I'm working under the table, well, they make that finding. If the person comes in, I got a new job, they make that finding. If there's a disability, they'll order that the hearing officer will order the payor to provide proof, to provide a statement from a medical professional about their ability to work, hopefully with an end date, meaning Sheree Wright can't work up until June 1st. And so we look for that end date. If they are able to work, we ask that the court order the payor to do a job search. More often than not, that's through Career Source of Central Florida, the state job agency. If there's a criminal history, we'll ask the court to order the payor to go through the bonding class there to get bonded and insured for employment. That's an additional step to make sure that the payor is looking for that job. And when they get that job, they can actually keep it. And along those lines, we want to make sure that they have their driver's license or any kind of license that's going to stop them from getting a job. That's what a motion to enforce tries to do, is try to get that payor back to work, to try to get money into that case. And if that doesn't work, we now have an order so that 3 months, 4 months, 5 months down the line, we can file a motion on contempt saying that the payor didn't do that. That gives us more ammunition in court to say we tried. And hopefully that doesn't happen and a motion to enforce does it, and the payor gets back to work and child support starts coming back in.
And if I could just add one thing related to the difference between the contempt and the motion to enforce. The reason we're doing the motion to enforce is because we don't have the information that shows that the parent who's supposed to be paying support had the ability to pay during that time. We have to have that verified info before we can refer a case for contempt. So if we don't have it, and we have many ways of, normally we do, but when we can't, then we want to still engage that customer if they haven't responded to some other administrative enforcement, to bring them in and try to get information, understand where they are, and help them get in a place where they can take care of their responsibilities. So it's an alternative to contempt that has a positive impact in that it allows the customer to share information, to get access to resources that they may not have been aware of, that will then hopefully result in compliance. And then if they don't comply with the motion to enforce order, then we have the ability to refer for contempt based on their non-compliance with some provision of that order.
Okay. Lots of detailed information. Very good, very good. All right, we're getting down to the last here. Next question, I'm having a hard time getting in contact with my baby father for a DNA test. I just took DNA test and my daughter, but child support can't get in contact with him. What are my next steps? It's been 2 years and no answers or response from anyone.
I would say reach out to the department to see where this case is. 2 years is a very long time without anything. And if this is an administrative case, they would be conducting DNA over there, the scientific paternity testing. If it's a court case, we've got different remedies. So you've got two different ways forward. So we need a little bit more information to know where the case is stalled, I would say.
Yes, and we're shortly going to put up the contact information here so everybody can see that. So last question, can child support be enforced to a parent that is illegal in the US?
I would say yes, but it's not as easy. There's certainly some difficulties around that. there's certainly, I can't presume that somebody who's not documented has the same work opportunity that other people do, but on the other hand, sometimes I say maybe it's time for you to return to where you can work because you decided to have a child and you're still financially responsible in this state because that's where this child is. But I acknowledge that definitely is a wrinkle and causes some issues. I don't know how you guys deal with it over on the DOR end, but that certainly is an issue that I've run across.
We've had it come up, someone's bad actions, whether that's being here illegally, whether that's going to jail, whether that's, I mean, there's a number of reasons why someone's bad acts, right? So you can't do something illegal or wrong and then use it as a defense for not paying your child support. So, you know, Judge, to your point, it's difficult to try to collect, to try to enforce a support order. But when it comes to that contempt proceeding, we don't ask about your status here. We don't ask about those things. We're just enforcing an order and asking you to pay. And if you have the ability to work, there's that presumption that you can pay.
Yeah, I mean, it's usually used as a defensive thing, but the reality is you're living, working, eating somehow. And so generally we delve a little bit for who's supporting you, and that's imputed income to you. So it does have, it is more difficult to impute income to that person, but it can be done.
Okay, wow. So guess what? We have come to the close of our webinar. Now, we have all these great panelists, our judge, our DOR, our staff here at Clerk of Courts that have given you all this time to give you all this important information. So here's the contact information. We were not able to get to every question. We had close to 50 questions here tonight. If your question didn't get answered, you can contact us. Here is the Clerk of Courts contact information, the phone number. And also the easiest way really to get a question answered is online at our website, myorangeclerk.com. Go to the contact us section and you can basically email in or put in your question. It will go to the direct department and we will email you back. Also, we want to give you the Department of Revenue representatives and their contact information. Here it is on your screen. David Gillen, which is david.gillen@floridarevenue.com. Cherie Wright, and that is CHERI.Wright@floridarevenue.com. So that is the contact information. If you didn't get your question answered, you can contact us and we will try to give you follow-up answers to all this. Now, before any of you all go, please, we have a survey at the end of our webinar here. We're really asking you to take. That helps us give us feedback. What you liked about this webinar, what you didn't like, what you'd like to see in the future, helps us to plan for more of these legal forums. And we do try to do at least 2 of these a year, which are provided free to the community as a service from our Orange County Clerk of Courts, Tiffany Moore Russell. So thank you to all of our panelists here tonight. Thank you for spending all this time. We even went over our time just to answer all these questions. This was great, great information. Anybody have a parting note? Say goodbye. All right.
Great to be with you.
Thank you for being with us. And again, at the end of this, so people asking about, hey, how can I look at this in the future? It's going to be on our website, myorangeclerk.com, also on our social media channels for the Clerk of Courts. So look for it there. And again, at the end of this, please take our survey. And thank you for joining us, everybody. Have a great night.